judgment in the appeal of Lee-Hirons and accepted for justice.
Lord Wilson will summarise the judgment to the court.
Mr. Lee-Hirons, the appellant, has the misfortune to have suffered mental disorder for many years. Numerous criminal convictions have been recorded against him. In 2006, following convictions for arson and burglary, the court made orders under sections 37 and 41 of the Mental Health Act 1983 that he should be detained in a secure hospital and that the power to discharge him should be exercised only by the Minister for Justice or a specialist tribunal. In June 2012, pursuant to a direction of the tribunal, the appellant was conditionally discharged from the secure hospital and went to live in a care home for ex-offenders. But 5 weeks later, he was recalled to a secure hospital, in other words, compelled to return there. Under Section 73 of the 1983 Act, the power to recall a conditionally discharged patient is given to the minister. To recall a patient to hospital is a profoundly serious situation for him, and the law attaches safeguards to the minister's exercise of his power to do so. As a member of a particularly vulnerable class, the patient is being deprived of his liberty, not by a court, but by the government, without having heard his side of the story, and in circumstances in which, back at hospital, he may be subjected to treatment without his consent. This appeal is about the explanation for the recall, which the law requires the minister to cause to be given to a conditionally discharged patient. The explanation given to this appellant falls into two stages. The first stage is the explanation which was given to him on the day when the recall took place. Shortly before the police collected him from the care home, his supervisor there simply told him that he was being recalled because his mental health had deteriorated. Was this enough? We've considered this in terms of his rights both at common law and under Article 5.2 of the Human Rights Convention, which provides that everyone arrested shall promptly be informed of the reasons for his arrest. We accept that it's often impracticable to give a detailed explanation to the patient at the actual point of recall, and that the law doesn't stipulate that more need then be said than what the appellant was then told. The second stage is the explanation which was subsequently given to the appellant, and in particular, the time when it was given to him. The fact is that it was only 15 days after his recall that the appellant was given an adequate explanation for it. The minister accepts that that delay in giving him an adequate explanation breached two separate but analogous rights of the appellant. First, it was published government policy that the explanation should be given within 3 days of a recall, and the appellant had a right to have the policy applied to him. Second, the explanation was not given promptly, as required by Article 5.2. So, what are the consequences of these breaches? The appellant argues that they made his actual detention during those extra 12 days unlawful. We disagree. We don't accept that the failure to give the explanation was so directly related to the decision to recall him as to have made it unlawful for the minister to have continued to detain him. We've also anxiously considered whether, for the breach of his convention rights, the minister should make some payment to him by way of damages. But the law says that damages are payable only when the breach crosses a certain threshold of gravity. And highly regrettable though it was, we don't consider that the breach crosses that threshold. These conclusions are essentially the same as those reached by the Court of Appeal, so today the appellant's further appeal is dismissed.